So previously I said that we would break contracts into three parts: the formation, the performance, and damages and defenses. And so on this next section we talk about performance. And there's a flip side to performance, which is to say breach. Breach is the failure to perform. So what we're going to look at in this lecture is performance and the breach of contracts for the international sale of goods. Now we start with the primary responsibilities of both the buyer and the seller in a sales contract. The primary responsibility of the buyer is to pay the price for the goods and take delivery of the goods. That's every buyer's primary responsibility. The primary responsibility of the seller is to deliver conforming goods, goods that match the general description, type, and quantity and quality of the offer, to deliver conforming goods in the manner specified for in the contract. Those are the performance obligations of each party: to pay for and take delivery of the goods, or to deliver conforming goods and deliver them in a manner specified in the contract. If a party fails to perform, then that party has breached the agreement. This is what breach means: it's failure to perform. And if a party fails to perform, that gives to the non-breaching party the right to seek a remedy, to cure the problem. Now, when we talk about remedies in the contract setting, the remedy is designed to put the non-breaching party in the same position it would have been in had the contract been performed. And that's a fundamental principle of contract law, and it differs from, say, tort law. Tort law is designed to put the victim back in the position they would have been in had the injury never occurred. In contract law, the goal of contract law is to put the non-breaching party, the innocent party, into the same position as it would have been in had the contract been performed. So in this lecture we're going to look at how buyers and sellers perform contracts, as well as the remedies that are available in case either party fails to perform. So we'll begin by talking about the performance of the contract. And once again, let me reiterate what the primary responsibilities of each party is. The buyer's primary responsibility is to pay the price for the goods and take delivery in the time and manner that the contract calls for. The seller's primary responsibility is to deliver conforming goods in the manner specified for in the contract. Now, keep this in mind as we go through this lecture and we talk about the performance of contracts under the CISG. The CISG does not replace the contract between the parties. Any of the provisions that we're going to discuss, or the remedies that we're going to discuss, or the definitions we're going to discuss, any of those can be supplemented, modified, changed, or otherwise annulled by the contract. It's the contract that's the most important aspect. What did the parties agree to in the contract? The CISG is not going to preempt the contract between the parties. Instead, the CISG, just like the UCC in the United States, is designed to be a gap filler, to fill in the gaps of the contract. Where a contract is silent on an issue, then the provisions of the CISG will apply. So what this does is it allows parties to enter into a contract, and they can be as specific or as non-specific as they wish, knowing that the provisions of the contract are going to be supplemented by the CISG. So any omissions in the contract, we can turn to the CISG for those terms. So the CISG acts as a gap filler. So we talked about the performance obligations of the buyer and the seller. Let's look more at what the CISG refers to specifically for the performance of the seller. Now, CISG Article 35 says that a seller must adhere to the terms of the contract. Furthermore, the seller must deliver goods which are of the quantity, quality, and description required by the contract, and which are contained or packaged in the manner required by the contract. So the seller has to deliver goods that are of the same quantity, quality, and description. When does he have to do that? Well, when we looked at time and place of delivery, understand, first of all, remember, the contract can provide for a different time and place. If the contract does not provide for time and place of delivery, then we're going to look to the CISG. And what the CISG says is if there's no agreement, then the seller must place the goods at the buyer's disposal at the buyer's place of business. So what is the seller's obligation? Under Article 35 of the CISG, the seller must adhere to the terms of the contract. Furthermore, a seller must deliver goods which are of the quantity, quality, and description required by the contract, and which are contained in packages or in the same manner as required by the contract. Now, time and place of delivery, when we look at that issue, this is often agreed to by the parties in their contract, and whatever agreement they make in the contract would apply. If the parties have not specified the time and place of delivery, then we turn to the CISG. And the CISG says if there's no agreement, the seller must place the goods at the buyer's disposal at the seller's place of business. So if, for example, a company in Belgium was buying goods from a company based in Houston, Texas, if the place of delivery is not specified in the contract, then the place of delivery is going to be at the seller's place of business in Houston, Texas. Regardless of where the contract was negotiated, regardless of where the contract was signed, if the contract is silent as to place of delivery, it's going to be at the seller's place of business. Now, if the time is not specified in the contract, and again, that's usually something the parties will agree to. If the time is not specified, the CISG simply says it must be a reasonable time. A reasonable time. And for reasonableness, we can look to what is the common in the industry. We can look at prior dealings between the parties. We can look at any other conduct between the parties to the agreement, to this particular agreement. So reasonableness is a broad category. So that's the performance of the seller. Now let's look at the performance of the buyer. Now we said the buyer's primary responsibility is to pay the price for the goods and take delivery of them as required. Failing to make a payment is failure to pay the price and therefore constitutes a breach of the agreement. Now, under the CISG, a buyer must pay the price without the need for any request or formality by the seller, any demand upon the buyer to pay the price. Instead, the buyer's obligation to pay the price is there simply because they're a buyer in the transaction under the CISG. In terms of place of payment, well, we've already discussed what occurs there. Time for payment, again, should be in the contract, but if not, the buyer must pay when the seller places the goods at the buyer's disposal. That's when the obligation to pay arises.